I'm going to talk to you a little bit about officer-involved shootings and the information that we rely upon to make these determinations. I would also point out that this is a subject that we have tried very hard to talk about, be disclosive about, add some transparency to. The second time that I gave a press conference on these weekly press conferences that you all are used to seeing me do, officer-involved shootings and the manner in which they are investigated and the rules that apply to the investigation was the subject of that second press conference. So it's something we talked about a year and a half ago. You should all have file footage on that. Again, to frame the assessment and the conversation, let me give you some background that I think is appropriate when we're talking about any investigation of the use of force by law enforcement, or frankly anyone. A couple of things have come into play. Number one, under Kansas statutory authority, we have just your normal self-defense law, 21-5222, pardon me, addresses that. We talk about in the statute the fact that a person is justified in the use of force against another person when and to the extent, I'm reading here, but when and to the extent it appears to such person, and such person reasonably believes that such use of force is necessary to defend against themselves or another person against the other's use of imminent and unlawful force. The point being, the word you'll see throughout the law, whether it's statutory or the constitutional cases of the United States Supreme Court, is a reasonableness. That is the determining factor. Specifically, there's also the statute 21-5227 that speaks to use of force during the course of an arrest by a law enforcement officer, and that's obviously specific to law enforcement and not something that applies to just your average person. But again, the terminology you'll hear as I read this, such officer is justified in the use of any force which such officer reasonably believes to be necessary to effect the arrest, and the use of force which such officer reasonably believes to be necessary to defend the officer's self or another from bodily harm while making the arrest. So again, the term of art, the term that the law proscribes is the reasonableness, an assessment of the reasonableness of the officer's behavior. Same as I mentioned earlier with just self-defense. There's a case that's very much the seminal case on analysis of use of force when it comes to law enforcement, and that is the Graham versus Connor decision, 490 U.S. 386. It's a 1989 decision, and when you read that and then you go back and compare it to 21-5227 out of the Kansas law, the statute I just read from regarding law enforcement officers' use of force, it's very clear that the Graham versus Connor decision serves as the basis very much for our law in Kansas. And the Graham versus Connor decision, as long as most Supreme Court cases are, but there are certain quotes that I put in this, I pulled from to put in the handout that was given out. It's not by any means the entirety of the opinion. It's much longer than that. But a couple of these really speak to the rule that the Graham versus Connor decision provides. All claims that law enforcement officials have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or other seizure of a free citizen are properly analyzed under the Fourth Amendment's objective reasonableness standard rather than a substantive due process standard. Sounds like a lot of legalese, but again, the term of art you're looking for there is the reasonableness standard. That's what they're saying, objective reasonableness. The second quote here in this handout is, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. That's a quote from the case. There's a couple others here that, again, I won't read to you. The law is pretty clear. And then the charging decisions, whether or not we can charge an officer or a citizen with the use of force is governed by a couple of things. One is the Supreme Court rule, which says prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. The national prosecution standards, which are not binding law but certainly provide guidance to prosecutors around the country, suggest that there's an additional factor to be considered, and that is you need to make sure that our duty as prosecutors, which are special responsibilities. A prosecutor has a set of responsibilities and ethical standards that are separate and apart from any other lawyer in the country. Rule 3.8 applies to me. It doesn't apply to any other civilian, any other civil lawyer, divorce lawyers, plaintiff's attorneys, etc., defense attorneys, frankly. It applies to prosecutors. And that is that we're supposed to be held to a higher standard. And among that standard, the National Prosecution Standards suggest that when deciding whether or not to file any charge, it has to be substantiated. The evidence must be there to support not only probable cause, but you have to make sure it's evidence that would be admissible. Saying I've got this evidence, but I know I could never get it in front of a jury, but it's a reason enough just to charge somebody just to see what would happen would be, frankly, unethical. So that's kind of how these things are guided. When it comes to an officer-involved shooting specifically, I think it's important to add a few things. Since taking over, I have had to have this kind of a conference on 2 occasions, and I issue a written ruling and a written determination as to what my findings were relative to an officer-involved shooting. One was the Wichita case on South Seneca. I then do something that has not been done around here for some time, and as I sit here right now, like I'm doing, and I answer questions. That won't always be possible. Some circumstances don't afford that, but where at all possible, what I've tried to do is add some transparency to this so the citizens understand how the process works. Additionally, when I took over, I talked to the sheriff and talked to the chief of police at the time, and I'm continuing these conversations with the current command staff of the police department. When there is an officer-involved shooting, how do we investigate it? How do we communicate it with the public? And you saw a couple weeks ago there was an unfortunate situation, but you saw a marked difference with the manner in which the Wichita Police Department handled the dissemination of information. Acting chief at the time, in Nelson Mosley's absence, was John Spear, and John stood up that Sunday evening and gave a press conference, and he showed pictures and he went through some detail. May not have seemed like an out-of-the-ordinary press conference as press conferences go, but if you have any institutional knowledge around here and understand how these matters are handled, it was a marked change. There is an effort to add transparency, to hear the concerns that have been raised in public settings, that faith in the system and the faith in the manner in which justice is meted out in this jurisdiction is enhanced by the free flow of information to the extent possible. Now, obviously, there are times when we can't, and there are as many rules that apply to me, 3.6, 3.8F, etc., that dictate how little I can say about cases when they're charged or when they're open or pending, etc. So there's a balancing act here, but I guess I'm not looking for a pat on the back, but I am hoping that there's a recognition that law enforcement in this jurisdiction, as well as this office, understands the need for this kind of a dialogue. Finally, to the nature of these investigations. Law enforcement investigates. Third-party law enforcement agencies are brought in. KBI, in the case of the Wichita case, Wichita incident on South Seneca, because the KBI, the FBI, or excuse me, KBI, WPD, and SO here in Sedgwick County had all been involved. We brought in Reno County to come in, a third party, to investigate this. When the investigation is complete, forensic evidence is analyzed, an autopsy is conducted. The autopsy, any results that the autopsy might show are analyzed. Ballistics, DNA, I mean, all of the forensic arts and sciences that would come into it are part of this. Witness interviews, if there's an ability to reconstruct trajectories and sort of the crime scene with photographs, measurements, etc., all of that plays into this. All of the officers' reports are analyzed. All of this is considered. There's no one thing as a general matter that's more important than another, but it's like any case. Every piece of evidence matters. If there's videotape available, if there's not, if there's a good eyewitness, what's the lighting conditions? I mean, these are things that really apply to every single case that we've ever analyzed and ever will analyze. So that's how this works. Again, this is an effort to have this conversation now so you have some notion as to what goes into this. So with that, I'm going to turn to the Lanning decision. Before I begin, I'll say again, we're doing this today rather than simply sending out a fax with this in an effort to do my best to be transparent about this. When I'm done, I trust you will understand, and you've heard what I'm about to say, that my ability to discuss and answer many more questions is very limited. And frankly, I won't take any questions about the Lanning case based on what I'm about to read. So, Wichita, Kansas, April 1st, 2012, officer-involved shooting. The Office of the District Attorney, 18th Judicial District, has conducted an investigation and review of a former police officer's use of deadly force resulting in the death of Mr. Troy Lanning, occurring on April 1st, 2012 in the 3500 block of South Everett in Wichita, Sedgwick County, Kansas. Consistent with protocol, the Office of the District Attorney reviewed the results of the investigation conducted by the Kansas Bureau of Investigation, Wichita Police Department, and investigators from the District Attorney's Office. The evidence reviewed includes, but is not limited to, the following: evidence gathered by crime scene investigators from the Wichita Police Department, civilian and law enforcement witness interviews, the results of the autopsy conducted on the body of Mr. Lanning by the Sedgwick County Regional Forensic Science Center, the results of the forensic examination of the bullets and shell casings, as well as the officer's firearm by the Forensic Science Center. The determination as to whether the officer acted reasonably in his use of deadly force under Kansas law requires a thorough assessment of the facts and evidence. Standing alone, the forensic evidence in this case, the firearm and ballistics, the crime scene analysis, and the assessment of trajectory included in the autopsy is not dispositive. The process of assessment requires the weighing of all available witnesses' statements. As has already been reported in the media, approximately 5 months after the death of Mr. Lanning, the officer in question filed a police report in which he made false statements. As a result, the officer was charged by this office and later pled to filing a false report and criminal damage to property. The officer today stands guilty of having made false statements during the performance of his employment as a law enforcement officer. The conviction for filing a false report has impacted both the investigation into the shooting death of Troy Lanning and its length. Based on the above, the Office of the District Attorney cannot and will not clear the officer of responsibility in the shooting death of Troy Lanning. Conversely, the available evidence does not provide a sufficient basis to establish that the officer did not act reasonably under Kansas law. Before the Office of the District Attorney issues a public finding that an officer was justified in the use of deadly force, there must be credible, objectively reliable evidence that the officer acted reasonably. In its absence, this office will not dilute the meaning of the phrase justifiable use of deadly force simply to conclude an investigation. The investigation into the death of Troy Lanning on April 1st of 2012 remains open. I appreciate your time. Copies of what I just read are available. Again, I would direct your attention to the release wherein I set forth the legal parameters, and I thank you for your time.